record in the matter of the people of the state of Michigan versus Oliver James Graham, file number 22-03463, council appearance.
Brian Ring on behalf of the people, pricing under Michigan Court Rule 8.120.
And Assistant Public Defender Sarah Donnelly on behalf of Defendant Oliver Graham, who is present and standing to my right.
How are you, Mr. Graham?
Hello. How are you?
I'm doing well. Today's date and time set for a final pre-trial. How are we proceeding on this?
Your Honor, this time we're going to leave it set for a jury trial.
Okay, this matter is set for jury trial on February 6th at 8 o'clock in the morning. Any additional matters we need to address today while we're on the record?
Yes, Your Honor, there is. In the meantime, Mr. Karatny and Mr. Graham, I apologize, Your Honor. Apologies. Mr. Graham, we need to make arrangements for him to go get his possessions and his dog from the home. There was permission to go over there with a police escort. It's just a matter of coordinating that so to make sure that the Ms. Graham or Ms. Huffman is at home when Mr. Graham brings an officer over. Mr. Ring and I wanted to do it on the record to get their availability in a time this week. After 5?
Any particular date after 5?
Any particular day?
Maybe to not to call the police.
Tomorrow, 31st after 5 works, Judge.
Okay, so the defendant can go tomorrow after 5 p.m. To retrieve personal items and his dog. Is that correct?
That's correct, Your Honor.
Okay. We noted here on the record. Any additional matters that we should address today?
Nothing on behalf of the people. Thank you, Your Honor.
And none for defense. Thank you, Your Honor.
Okay, you're all set. We'll see you next week in person for the jury trial.
Thank you, Judge.
Thank you.
Just
On the record, the matter of the people of the state of Michigan. What happened to Joan? I don't know the file. Okay. Versus Samara Nichelle Jones, file number 22-03462, council appearance.
Brian Ring on behalf of the people, pricing under Michigan Court Rule 8.120.
John Lee on behalf of Samara Jones.
Okay, Ms. Jones, how are you?
Good, how are you?
I'm doing well, thank you. Today's the date and the time that was set for a final pretrial on count of domestic violence. I have here a motion to nolly from the people. They are not able to proceed at this time because the necessary witnesses failed to appear. So they're moving to dismiss without prejudice. They're also objecting to the destruction of records under MCL 764.26A. Counsel, did you advise her of what that means?
No, we have not had an opportunity to discuss that.
Okay, so they're objecting to the destruction of your arrest records, fingerprints and such of that nature, likely due to the fact that they think that this is a case that will be reissued. Do you understand that?
Yeah.
Okay, and so the motion to dismiss is without prejudice. That means that they have the right to reissue the charge against you within the statutory time frame if the necessary witnesses re-engage with the prosecution's office and they're ready to proceed. Do you have any questions at this time about that? Okay, I'm gonna get you a copy of this nolly and you'll be all set. Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
Nothing for the defense, Your Honor.
Thank you. Who wants the record? On the record in the matter of the people of the state of Michigan versus Brett James Krotny, file numbers 22-03378. Council appearance.
Brian Ring on behalf of the people practicing under Michigan Court Rule 8.120.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Brett Karotny, who is present and standing to my right.
Okay, Mr. Krotny, today's the date and time that's set for both a final pretrial on one count of domestic violence, and I have a PA 53 violation arraignment that needs to take place today. What's going on with the final pretrial?
The witnesses are here, Your Honor. There is currently no offer. Mr. Karotny, right now is in a lot of pain. He has an infection in his face. He should have been in the hospital, but he didn't want to get a bench warrant, so he's here. I believe he's at this point in so much pain, he's willing to accept whatever he can, but I don't feel comfortable with that. So, Your Honor, the necessary witnesses are here today to proceed with both the PA 53 and a jury trial. We accept that. We would like it to be set for a plea, and at that point, we'll hopefully resolve this matter with, but Mr. Karotny is not in a state right now that I would want him to proceed with any sort of plea.
Okay, so you want the set for a plea versus continuing to a trial?
Yes.
Okay. Okay, and as to the alleged bond violation, I have a police report here. It's dated for January 4th. The allegation of Mr. Karotny is that you violated the terms of your conditional release from custody by making a contact either directly or indirectly with the alleged victim, Alicia Tiana Harden, in violation of the bond conditions that was issued to you by Magistrate Milmore back on December 5th. I think you were previously arraigned on another bond violation. So this is a second bond violation or allegation of bond violation. So you have the right to have a contested hearing on this. And you have the right to be represented by counsel at that contested hearing. You have the right to have the prosecution produce sufficient evidence to prove beyond a reasonable doubt that you violated the conditions of your bond. Do you understand that? If you're found to be a violation of your bond, you're subject to a contempt of court order, and you can face up to 93 days in jail and or $7,500 in fines. Do you understand that?
Yes, Your Honor.
Okay. Equivalent to a plea of not guilty on your behalf at this time. We'll continue this hearing on the PA 53 violation to the date and time set for your plea, which is going to be February 6th. And that'll be in person at the court. Any additional matters for the record?
Not right now, Your Honor.
Nothing to appeal, thank you, Your Honor.
Oh, the only thing is your address. What's your updated address? 406 West Willow. Is there an apartment number? And you know the zip code? You're just waiting for notes.
Any additional matters for the record?
Nothing
No,
to
no,
appeal,
no.
thank you, Your Honor.
Okay, you're all set, sir.
4906, Your
We
Honor.
get some medical attention.
Yes. Yeah, you can go. I'll get you your notice to appear and give it to you.
We're on the record in the matter of the people of the state of Michigan versus Erica Matthews, file number 22-03471, council appearance.
Brian Ring on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of defendant Erica Matthews, who is present and standing to my
Jackie, how are you? I'm doing well. Today's the date and time that's set for final pretrial on one count of domestic violence and then also a TA 53 violation hearing. We have a Nolly cross here from the people. They're unable to proceed at this time because the necessary witnesses failed to appear. They're also objecting to destruction of the records under MCL 764.26A. Is that correct?
That's correct, Your Honor.
Okay. Ms. Donnelly, did you advise your client of that?
No, I have not advised my client of that. I can tell her about that, but I would be objecting to that. Objection to destruction. There's no, my understanding is that this is a policy put out by the Ingham County Prosecutor's Office for all of domestic violence charges, but this is something that basically there's no appeal for. There's no process to eventually get it off of your arrest record. So for Ms. Matthews and her criminal history, it basically leaves on her arrest record forever a domestic violence charge, which and of course, we're here today and getting this, and it's being dismissed because the necessary witnesses didn't proceed. She's not being found guilty of anything beyond reasonable doubt. And there's no, again, they're not, the prosecutor's office isn't doing this because of anything Ms. Matthews did. They're just doing this as a policy in general. But in Ms. Matthews' case, I would be objecting to that objection to the destruction of the arrest records. Thank you.
Mr. Ring.
Your Honor, there's no mechanism for an objection to that destruction. The MCL reads that if the prosecutor in the case agrees at any time before the case is dismissed, or the prosecutor of the case and the judge in court in which the case is filed does not object within 60 days, then everything will be destroyed. So it's destroyed unless I object. There's no mechanism for any objection to my objection to the destruction of those records, Your Honor.
I would agree. And so the Nolly will be signed and the order will enter with the objection to the destruction of the arrest records under MCL 764.26A. I recognize the concern of the position, and it's important that you make that objection to the extent that the public defender's office wants to move in a different direction to have that address and maybe create a mechanism, but at this time there is not one. So the arrest records will not be will not be destroyed in this particular case. And without the victim, I don't think we can address the PA-53 violation.
That is correct, Your Honor.
So that will be dismissed as well at this time. Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
Thank you, Your Honor. No, nothing offense.
Okay, we'll get your copy of the Nolly there. On the record in the matter, the people of the state of Michigan versus Ashley Elizabeth Smith, file number 22-03044. Council appearance.
Brian Ring on behalf of people practicing under Michigan Court Rule 8.120.
John Lee on behalf of Ashley Smith.
Okay, Ms. Smith, how are you? I'm doing well, thank you. Today was the date and the time set for a jury trial for one count of domestic violence. And my understanding is that there is a Nolly, the necessary witnesses failed to appear. So the people are moving to dismiss without prejudice at this time. That simply means that if the necessary witness re-engages with the prosecution office, they do have the right within the statutory time frame to reissue the charge against you. Do you understand that? Do you have any questions at this time? Okay, I'm gonna sign the order entering the dismissal and you'll get a copy of that in just a moment, okay? Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
Nothing on behalf of the defense. Thank you, Your Honor.
Thank you, Your Honor. On the record in the matter of the people of the state of Michigan versus Stephanie Fisher, file number 22-03325. Council appearance.
John Lee on behalf of Stephanie Fisher. I apologize, Your Honor.
No problem. Ms. Fisher, how are you?
I've been very,
I'm pretty good. Where are you from?
basically here from Sister Ray.
Take a moment. You said that you're basically here because your sister hates
My
you,
sister hates me.
and your sister's the victim in this matter.
Yes.
Well, what makes you think that your sister hates you?
We've just never really gotten along. It's always something I'm doing. She can never really tell you what I've done. I'm just always negative. I wasn't the perfect little sister, but I literally did nothing to my sister in the last 20 years of my life. So she's just holding what I did to her as a teenager against me.
Okay, well, how does that incident relate to why you're before the court today?
Because that's the fight. I was in the fight with my sister. There was a previous incident before this, where I don't know if I can say it before, she pulled a gun on me. The charges got dropped. They didn't believe she pulled a gun on me. But at the time of the fight, I was under the impression that I still had charges pending against her. And what do? Let alone your sister and the person who pulled the gun on you was standing in front of you in your house and won't leave. I asked her to leave. My mother asked her to leave. She refused to leave. And we got into a fight and I went to jail for defending myself. To this day, I'm still terrified to even be outside or anywhere by myself because my sister pulled a gun on me and nobody believes me. So for her to be in my house, in my face, refusing to leave, we fought. And yes, I did remove my sister from my house.
The address of the incident was your home, ma'am?
Yes,
Your sister lives there?
no,
You advise your attorney of that?
yes,
And with that understanding, you waived your right and entered a guilty plea to disorderly jostling?
I can't risk going to jail, taking this to trial. I'm the only person who takes care of my mom. I can't risk losing my child and going to jail. My mother won't have anybody to take care of her. So I have no choice to take the plea.
Well, you had a choice.
I mean,
You made
in hopes that
a decision,
I did, but
and
I just didn't want to risk taking it to trial and possibly losing and getting a felony on my record and going to jail.
this is a misdemeanor. It's not a felony. It's a misdemeanor that even if you were to be found guilty of, which it does sound like you thought or you believe based on some of the information you just shared that you had a defense to the underlying charge. Something you should have had an in-depth discussion with your attorney and weighed your options. We could have had a COGS discussion. And your attorney could explain what that means. Even if you were found guilty of an assault and battery and misdemeanor, the likelihood of you going to jail is extremely low. You should never waive rights to get a matter over with. I asked you on the record if you were pleading guilty because you believe you were guilty.
I mean, I fought my sister, so I mean,
Correct. No, the fighting though is not in and of itself guilt. I'm not your attorney. I don't know the facts, all the facts of the case, but I know what you just shared here. And it sounds like you believed you had a defense to the charge. This was your home,
Yes, Your Honor.
and this was not her home.
No.
I can't speak to whether or not your sister hates you. I don't know your relationship. But it does sound, based on what you're saying here, that there is there's a strain there. And that's unfortunate because family is really all you probably have and what you need to rely on. You sound like you have a lot on your plate. You're dealing with your mother. I don't know if your sister is helping you with your mother. To the best of your ability, and you can't make your sister do anything. And given the charge that you have here, I wouldn't even order you to undergo any treatment. The charge that you pled to, that is. But you all need to try to figure out a way to come to some resolution and some resolve. Your family. You should be able to have a amicable, peaceful relationship with your sibling. And none of it is worth you all putting your hands on each other or pulling guns on each other like you're strangers in the middle of the hood. That's unnecessary. You're not gonna always get along. That's common with siblings. I've got sisters. Sometimes I don't get along with them. Whether I'm right or they're right, whether I believe I'm wrong or not, I try to make sure to the best of my ability that I still treat them with love and respect when I can. That you're in control of your behavior. And so if your sister was in your home and you wanted her to leave, you could have called the police. Did you wait for the police to arrive before you engage with your hands? That's a decision that you made. You understand that? So you have to start to reflect on what decisions you can make in this situation. You can't control her actions. You can't control yours. And I think that this was a situation where I did not refer you to probation for a pre-sentence report because of how reduced the charge was, but I wanted to see your prior criminal history to see if this was something or this was a pattern of behavior for you. It does not appear this is the pattern of behavior. You did have some prior engagement with the criminal justice system, but it was not engagement that involves assaultive behavior. So with that being said, I'm not going to sentence you to any probation. I'm not going to sentence you to any programming. I am going to admonish you to try to make better decisions about your interactions. I know this is your home. Unless you felt like your life or your safety was at risk, you should not have put your hands on anyone. You should have allowed the law enforcement to take control of the incident. If you were going to call the police, you should have waited for them to arrive to remove your sister from what is your home. With that being said, there's a $75 crime victim rights fee that will be assessed. Can you make payment on that?
I might pay them first.
Okay, I'll note that you'll make payment on the first. Do you have any questions at this time? Any additional matters for the record?
No,
You're all set, ma'am. Good luck to you and your family.
What's that? Oh, she's-
Have we seen the Tama Haptalim? No. I'm sorry? Already in your instance. On this file? Who said it for show costing? Got it. Think that's it. Thank you. I forgot. So it looks like- Okay. Can you hear me, Mr. Russell?
Yes,
Okay, your attorney
yes, I
wants to
can.
meet with you. We're gonna put you in a private meeting room with your attorney.
Okay, thank you.
Did we get Mr. Mr. Robbins? Wait, who's giving you the
Russell.
Russell? Okay. You didn't give it to me yet. Simmons, Robbins. He has not yet corrected. He's to speak to. Okay. And who's getting dismissed? Mr. Ring, are you moving to dismiss the matter against Robbins?
That's correct, Your Honor.
Okay, Mr. Robbins, your matter is dismissed.
Okay, thank you.
You're welcome.
Have a good day.
Same to you.
You can go whoever's there.
Bench warrant. Did you give Russell a date?
I didn't tell him. It's March 6th at 1.
Mr. Russell?
Yes.
Your matter is gonna be reset for March 6th. You said at 1:30? At 1:30.
Okay.
All right, you're all set. Thank you.
All right. Thank you. Have a good day.
Same to you. Jessica West failed to appear.
Your Honor, Jessica Wett is also known as Jessica Standish, and she has 5 other cases set for March 6th in front of you. She also has a felony in front of you and other, I talked to her on Friday, but her phone is disconnected at this moment. I'm just wondering if I could get time to locate her. But she's gonna be in front, she's supposed to be
She
in front
failed
of
to
you.
appear one day last week and then came later. Yeah, she's gonna keep it for the court dates. Not babysit and track people down. You have the number ending in 2083?
Yes.
I had 2 last night. Let's see, that's a 2. I'll hold for 48 hours.
Thank you, Your Honor.
Sarah,
Hmm.
do you have? I have that. Usama.
Usama Yamada?
Yeah.
He's probably outside.
Okay, I was saying.
We're just gonna set it for a final pre-trial.
I'm sorry?
It was like the victim called
Oh, yeah.
back in December asking if you had been deported back to Israel.
He's, on my understanding is there's probably are proceeding on deportation service, you know, because of his, he took a felony to a broader criminal thing. So, yeah, he's been in custody for quite a while. But it's my understanding that there, I think he's in custody. But he has a lot of family.
Passwords expired.
Oh, boy. Where she got picked up?
Jessica.
Yeah, just like her Eaton County Public Defender thought she was still in Eaton County PD. or county jail. Let's see. Somebody bought it?
Yeah.
Are you still doing that, or did you finish up the
Yeah,
counter?
yeah.
Okay.
Yeah, I think.
Yeah, you haven't seen me. I don't think we've met in person. Yeah. Oh, so when you got charged, they always usually come out and looking at the rest. Some sort of a sexual assault less than.
Yeah.
It's very clear, generalized terms on the rest. But then you have the charging portion, that's what prosecutors actually end up writing for, and then the adjudication. is the part right one. So the rest is what police do, they only have certain things, intern and all this.
But it says I had a felony.
But what's up? Oh, it says a felony. You were convicted of a felony.
No.
And what kind of felony are we talking about?
He said I had a felony of assault less than an assault non-sexual.
Well,
It's like that in the first form, but then the second one
Yeah,
says
yeah.
it's a misdemeanor,
yes,
and the third one says, no information.
yes, exactly, because that's the current charge. Yeah, you gotta, that's true. Yes,
So they reduce it.
it's just, that's the arrest record. Right now, everyone who gets arrested and charged, it all goes on a criminal history.
But see, they may not later on charging that to me.
They charge you, yes, that's what it means. You got charged, you got charged with misdemeanor.
Yeah.
So you got, here, you got, so yes, it says arrest segment, felony assault excluding sexual. You got arrested on July 4th.
Yeah.
You got charged with misdemeanor assault or something.
Oh, so-
That's what it means.
So originally they went down with this, but then.
They were seeking, you were
Yeah.
arrested on a possible felony assault excluding sexual, and that's what happened. That's what got arrested. Yeah,
So the lawyers look at this, right?
judicial segment is what actually happened to the
Yeah,
case.
yeah.
Yeah.
Yes.
Mhm. I do. All right, great. Thank you. 14 minutes.
Okay,
Try to clear that up in a second too.
okay. We ready on Sorrel?
Yes.
We're on the record in the matter. For the people of the state of Michigan, which is Erica Sorrel, I have file number 22-03172 and 22-03293. Council appearance.
Fran Ring on behalf of people practicing under Michigan Court Rule 8.120.
John Lee on behalf of the defendant, Ms. Erica Sorrell.
Today's the date and time set for pre-trial. I have one dog at large, one vicious habits dog. How are we proceeding?
Your Honor, the prosecutor and I have worked out a plea deal. Ms. Sorrell has agreed to plead guilty to the dog at large charge, and the prosecutor will dismiss the vicious dog charge.
Is that correct?
This is correct, Your Honor.
Okay, and Sorrel, you heard the offer that was extended by the people.
Yes, I did.
You want to accept that offer today?
Yes, I do, ma'am.
Can you please raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, I do.
Okay, you put your hand down. Is there somebody over to the side that you need to get approval from?
No,
Okay,
I was looking at my daughter.
okay,
She's
sounds good. Today's the date and time that was set for the pre-trial on the dog at large. You have the right in this matter to proceed to a jury trial, though. At the time of jury trial, you have the right to have the prosecution bring sufficient evidence to prove each element of the charge being brought against you beyond a reasonable doubt. Do you understand that, right?
I do.
So you would have to give up your right to trial in order to plead guilty. Is that what you want to do?
I do want to give up my rights.
Okay, so that means you're also giving up your right to the presumption of innocence. So you're innocent until proven guilty. You also are going to give up the right to have the prosecution prove each element of the charge being brought against you beyond a reasonable doubt. You're going to give up your right to remain silent at trial and not have silence be used against you. You're going to give up your right to see, hear, or question any other witnesses the prosecution intends to call, or to call your own witness at trial and present evidence that you believe would further defense to this charge. Do you understand that?
I do.
Anybody threaten you to get you to waive your rights and plead guilty?
No.
Has there been any promises made to you in exchange for you pleading guilty today?
No.
Are you pleading guilty to dog at large because you believe you're guilty?
Yes.
As to the charge of dog at large, how do you plead?
Guilty.
Factual basis, please.
Ms. Sorrell, on or about November 18th, 2022, were you at your home on 230 Hill Street, Lansing, Michigan, County of Ingham, State of Michigan?
Yes.
And at that time, did your blue pit bull escape out the front door and run down the street?
Yes.
I believe we have established the factual basis.
Mr. Ring,
No further questions, Your Honor.
court is satisfied with the factual basis. I will accept your plea. Find your plea to be made freely, voluntarily, and intelligently. Your fine is $100. When can you make payment?
On February 28th.
Okay, you can make payment by coming in person and making payment at the criminal traffic window, or you can mail check or money order to the court using your case number, or you can make payment on the court website using your case number. Do you understand that?
I do.
Okay, and the other file will be dismissed per the plea agreement. Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
Nothing for the defense, Your Honor.
You're all set, Mr. Rowe.
Thank you.
You're welcome. On the record in the matter of the people of the state of Michigan versus Usama Ibata, file number 22-01765, council appearance.
Brian Ring on behalf of the Appeal Practicing under Michigan Court Rule 8.120.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Usama Abada, who is present and standing to my right.
Thank you. Today's the date and time that is set for a pretrial on one count of assault and battery. How are we proceeding?
Your Honor, it's my understanding there isn't an offer at this time. We'd be requesting final pretrial and jury trial.
March 6th at,
Jury trial.
what is that? What's that on Monday? March 6th, and then jury trial when?
March 13th.
Okay, final pretrial will be March 6th at 8 o'clock in the morning in person at the court. Jury trial will be March 13th. 8 o'clock in the morning in person at the court. You understand that you need to appear on those dates in person? Okay. Do you have any questions today, sir?
No, Your Honor, thank you.
Okay, any additional matters for the record, counsel?
Nothing on behalf of the people. Thank you, Your Honor.
None for defense.
Okay, you're all set. We'll get you a notice to appear. Who is that you have?
This is Angus McFarland, Your Honor.
On the record in the matter.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Angus McFarland, who is present and standing to my right.
And how are you, Mr. McFarland?
I'm doing well.
Today's the date and time set for pretrial. I have a count of operating while intoxicated, second offense notice. How are we proceeding?
Your Honor, it's my understanding, well, this is our first pretrial conference. Actually, I tried reaching out to Mr. McFarland, but this is our first opportunity having to be able to talk. So I'm going to provide him the evidence and hope and follow up with that. Mr. Ring had also an issue he wanted to look into, Your Honor.
That's correct, Your Honor.
So do you want to set this for just adjourn it pretrial or set it for?
Let's set it for a plea.
Yours pretrial.
Or we can set it for a final
There was an
plea.
offer extended?
There's
Not
no
at this
offer
time.
yet.
There will be one
So the-
forthcoming though.
Let's just
We
do
can set
another
it for
pre-trial
pre-trial.
because he's got to get the offer and
Sounds
then
good.
consider the offer. So let's just do a pre-trial. March 6th at 2:00. You must be super busy on March 6th.
We are, but that's several Mondays before that are close to be a holiday.
Well, I got jury duty.
You hope.
I got my civic duties to perform and I better get chose. Okay, well, March 6th at 2 p.m. Any additional matters for the record?
No, bad people. Thank you.
No, Your Honor.
Okay, we'll get you a copy of your notice, sir. Where's the jail with our people?
Clark was read over, so he's downstairs.
Oh, okay, well, there's that. Are we having a hearing or was it just an arraignment?
No, yeah, we're no.
Donald,
Yes, I'm sorry, Your Honor.
I can't read this handwriting.
Carlos Clark,
For Carlos Clark?
have a hearing.
No, I'm setting it for final pretrial.
What is this? There was an offer on Clark.
There wasn't at this time, Your Honor.
And jury trial. Final pretrial March 6th. Yes, please. It's not an easy one. Advise me what's going on now.
For Stella Hernandez. It
Yeah. Yeah, absolutely.
sounds like her license is revoked, so.
Yeah.
Yeah, I'll take one downstairs.
She was restitution. I think it's murder. I think this is the one with the 13-year-old son. Is that this one?
It happens. No, this one got loose and then ran into a chicken coop.
This is the chicken coop case.
This one got into the chicken coop.
Yeah. Oh.
Did we talk about this one?
Yeah, this is the one where she normally puts the dog on a chain outside, but she had let her pit bull, her 3-month-old pit bull out 3 days. Just
Morning, who just joined on the iPhone?
Yes.
What's your name?
Estella Hernandez.
Okay. Mr. Lee, is that you?
No. Just double check. That's probably missed out.
There's always handgun crisis, and if people have handguns, people get shot, killed, and for deterrence of others. So it's a sense of core that Mr. Allen paid prime victims fought 130, state costs of 136, attorney fee 500, fine of 100, cost of 700. In regards to count one, I am going to file a recommendation since Mr. Allen did not less than 18 months or more than 60 months at the Michigan Department of Corrections credit for 128 days. And in count two, I'm going to sentence Mr. Allen to 128 days, excuse me, 120 days credit for 120 days. On count two.
Inmate on phone if I'm in a court.
Notice of past practice. I advise you, your child file an application for leave appeal. The application must be filed within 21 days of your receipt of the form. You're not entitled to have a lawyer appointed public expenses represent you unless you meet the requirements listed on the form you receive. The request for a lawyer must be made within 20
Mr. Zarka, if you see a request that says join, you need to click it, sir.
days.
Hurry.
Yes.
I'm sorry. Commanders? James, listen. Okay, are we ready on Zarka?
Yes.
Well, on the record in the matter of the people of the state of Michigan versus James Anthony Zarka, file number 22-01659, council appearance.
Brian Ring on behalf of the people practicing under Michigan Code Rule 8.120.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant James Zarka, who is appearing from the Ingham County Jail by video.
Okay, Mr. Zarka, today's the date and time that was set for a pre-trial. We adjourn this so that he can be screened for drug court. Did they get that taken care of?
No, Your Honor, they haven't. I have had no further word since January 9th on drug court. Well, what I have heard today was that Ms. Eisler, the drug court probation officer, resigned January 20th.
Oh.
So yes, the defense has been in an effort to get a global resolution, having Mr. Zarka screened for drug court. At this point, the plan is still getting him screened. They're still doing that, I imagine. But
we'll set it out 30 days. If we can move it up quicker, we'll do that. But
6 and 2.
well, you're in control of the setting. Why would you jam us that way? It's not necessary.
Okay, the 13th.
Well, I mean, we might be having trial on 13th. What time?
9.
Okay, March 13th at 9 a.m. Any additional matters for the record today?
Nothing on behalf of the people. Thank you, Your Honor.
enough for defense. Thank you, Your Honor.
Okay, you're all set for today, Mr. Zarka.
Thank you.
No problem. On the record, in the matter of the people of the state of Michigan versus Estella Hernandez, file number 21-03132 ST, council appearance.
Brian Ring on behalf of the people practicing under Michigan Code Rule 8.120.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Estella Hernandez, who is appearing separately by video.
Can you hear us, Ms. Hernandez? You're muted.
Yes, I can hear you.
Okay, very good. I have here a plea offer from the people. They're stating that they're offering for you to plead guilty to an added count 2 of allowing a suspended person to operate a motor vehicle under MCL 257.042A. That's a misdemeanor with a maximum penalty 93 days in jail and or $500 in fines, and they'll dismiss the original count. Do you want to accept that offer today?
Yes.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Thank you. You can put your hand down. Okay, Ms. Hernandez, in this matter, you have the right to proceed to a trial. You have the right to have a jury trial. At the time of trial, you have the right to the presumption of innocence. So you're considered innocent until the people can prove you guilty. You have the right to have the people prove each element of the charge being brought against you. They have to prove each element beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used against you. You have the right to see, hear, or question any of the witnesses the prosecution intends to call, or call your own witnesses, or present evidence that you believe would further defense to the charge. In order to plead guilty to the amended charge, you would have to waive your right today to trial and to the other rights that I just listed there. Do you understand that?
Yes.
You want to waive your rights today?
Yes.
Okay, anybody threatening you to get you to waive your rights and plead guilty?
No.
Any promises being made to you in exchange for you entering a guilty plea today?
No.
Okay, you're pleading guilty because you believe you are guilty.
Yes.
As to the added count 2 of allowing a suspended person to operate a motor vehicle, how do you plead?
Guilty.
On a factual basis?
Thank you, Your Honor. All right, Ms. Hernandez, on November 13th of 2021, were you operating a vehicle on eastbound I-496 near Pennsylvania Avenue in the city of Lansing, Ingham County, state of Michigan?
Yes.
And at that time in place, when you were operating that vehicle, was your license revoked?
Yes.
All right, and you were pulled over by a Lansing Police Department officer, correct?
Yes.
All right, and at this time, is your license still revoked?
Yes.
All right, Your Honor, I'll go for the questions.
Any questions from you, Mr. Ring?
No, thank you, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. Your fine is $200. When can you make payment?
Is there any way that I can have at least a couple of, or a month or two just to have it paid off?
I know here that you'll make payment within 60 days. You can make
Yep.
payment by going to the court website and using your case number, or you can come up to the building and go to the criminal traffic window and make payment there. Or you can mail check or money order to the court and attach your case number to the check or money order, okay?
Okay.
Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
And none for defense. Thank you, Your Honor.
You're all set, Ms. Hernandez. Thank you. Laquan Williams. On the record in the matter of the people of the state of Michigan versus Laquan Williams, file number 22-02937, council appearance.
Brian Ring on behalf of the people practicing under Michigan Court Rule 8.120.
Thank you. Mr. Williams has counsel or no? Okay, today, Mr. Williams, is the date and time set for a pretrial on an unlicensed dog. You're proceeding today without counsel. Was there an offer on this?
Sorry, Your Honor.
How are you proceeding?
Your Honor, this time the people moving to dismiss.
Motion to dismiss is granted. This case is dismissed. You're all set, sir. You're welcome.
Hello.
Okay. Hello.
Hi, how are you?
I'm pretty good. How are you?
Good. Okay.
Cindy, Casey, T. Janina.
I am, Your Honor.
Do you need to speak to her privately?
No, we're all set to go.
Very good. We're on the record in the matters of the people of the state of Michigan versus Kathy Lynn Tijarina, file number 22-03050 and 03051. Council appearance.
Brian Ring on behalf of the people practicing under Michigan Court Rule 8.120.
John Lee, on behalf of Casey Tangerina.
Today's the date and time set for a free trial. I do have a plea sheet here. It says that people are offered for the defendant to plead guilty to the charge in file number 22-0350, and they will dismiss the case ending in 03051. Does your client want to accept that?
Yes, Your Honor.
Okay, Mr. Tijarina, do you want to accept that offer?
Yes.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes.
Thank you. You can put your hand down. It would be nice if they tell me which charge. I'm supposed to highlight which one it is. It's a citation. It's the dog at large. Pleading guilty?
Yes, that is correct, Your Honor.
Okay, Ms. Tijarina, you've been charged in this matter with a dog at large.
Yes.
So you have the right to proceed to a trial. It's a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines. You have the right to proceed to a jury trial. You have the right to have the prosecution prove each element of the charge being brought against you beyond a reasonable doubt. You have the right to call your own witnesses or present evidence that you believe would further a defense to this charge. You have the right to remain silent, not have silence be used against you, and you have the right to the presumption of innocence. So that means you're innocent until the people can prove you guilty. Do you want to waive your right today to plead guilty to the dog at large?
Yes.
Okay, anybody threatening you to get you to waive your rights and plead guilty?
Nope.
Any promises being made to you in exchange for you waiving your
No.
rights to plead guilty today? Okay. And you're pleading guilty to the dog at large because you believe you're guilty?
Yes.
Okay. As to file number 22-03050, which is dog at large, how do you plead?
Me, oh, sorry, guilty. I never done this before.
Factual basis.
Ms. Teaserina, on or about October 27th, 2022, were you and your dog in your home at 3206 West Holmes Road?
Yes,
And that is in the city of Lansing, county of Ingham, state of Michigan, correct?
yes,
And your dog did push open the back screen door and get out and run down the street, correct?
yes. I had a puppy that I was letting out in the middle of it was like 4 o'clock in the morning, and the door wasn't latched all the way, and he bumped it open with his nose.
Very good. No more questions, Your Honor.
Any questions for you, Mr. Ring?
No, thank you, Your Honor.
Okay. The court is satisfied with the factual basis. I'll accept your plea, affirm your plea to be made freely, voluntarily, and intelligently. Let's see. Okay, the dog malicious destruction of property is dismissed per the plea agreement. Your fine is $100. When can you make payment?
I get my check on the 1st, so it comes in the mail usually a couple days after that. I could probably make at least half of that.
Okay, so you're gonna pay $50 on the 1st, and then when are you gonna pay the balance?
Well, I'm unemployed right now, so the only money that I have coming in is my utility check from Section 8. And I get 200 a month. So I was gonna take 50 out of that if I could. And then if I have enough time to wait for another check to come, because that's usually what I pay my bills with.
Okay, so you're gonna pay $50, you said, on the 1st,
Uh-huh.
and then March 1st, you'll pay the balance?
Yes, yep.
Okay. Okay, you can make payment on the court website using your case number ending in 3050, or you can come up to the criminal traffic window and make payment that way, okay?
Awesome. Thank you.
No problem, you're all set, ma'am.
Thank you. Have a good one.
Same to you.
Yep, bye-bye.
And then Mr. Wayne is here, and he's being represented by Mr. Samores.
Yeah. Mr. Samaras?
Yes, thank you. Sorry about that.
It's all right. Did you need to speak with your client, Mr. Wayne, or were you ready to proceed?
I think we're ready. We spoke. Mr. Wayne, do you have any questions? I think we spoke already and we know how to proceed this morning. That's my assessment. Is that fair?
Yeah, I'm ready to go.
Okay, thank you. We are ready.
Okay, we're on the record in the matter of the people of the state of Michigan versus Tyler Matthew Wayne, file number 22-03317 SD, council appearance.
Brian Ring on behalf of the people practicing under Michigan Code Rule 8.120.
Good morning, Your Honor. Peter Morris here on behalf of the defendant who is present via Zoom.
Today's the date and time set for a pretrial on operating while intoxicated. How are we proceeding?
There was I don't think we put this on the record last time, but there was an offer of impaired. I forget if it formally included a no upfront jail. I know they usually do. This is a true first offense in every which way.
Okay, I see here an offer from the people for the defendant to plead guilty to the added count 2 of operating while impaired. That's a misdemeanor with a maximum penalty of 93 days and/or $300 and/or 360 hours of community service. If the people would dismiss the original count 1, I do not see a killer boo agreement.
I'm happy to add it at this time, Your Honor.
Thank you.
We're also adding a killer boo agreement, and so they are agreeing they should be sentenced without upfront jail. Just for your information, though, Mr. Wayne, I'm not a party to that agreement, okay?
Yes, Your Honor.
Okay, did you want to accept the offer today?
Yes, Your Honor.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, Your Honor.
Okay, you can put your hand down. Mr. Wayne, in this matter, you have the right to proceed to a trial, and you have the right to a jury trial. At the time of trial, you have the right to have the prosecution bring sufficient evidence to prove each element of the charge being brought against you, and they have to prove each element beyond a reasonable doubt. Are you willing to waive your right to trial in order to enter a guilty plea today?
Yes, Your Honor.
Okay, so that means you're also going to give up your right to the presumption of innocence. So you are considered innocent until proven guilty, but you could waive that right today to enter a guilty plea. That's what you want to do?
Yes.
Okay, you're going to also give up your right to see, hear, or question any of the witnesses the prosecution intends to call. You're going to give up your own right to call your own witnesses or present evidence at trial that you believe would further defense to this charge. You're going to give up your right to remain silent, not have silence be used against you. You understand that?
Yes, Your Honor.
You're going to also give up the right to make a claim that you pled guilty because someone forced you or you were threatened to do so. Is there any promises being made to you in exchange for you waiving your rights and pleading guilty today?
No, Your Honor.
Anybody make any threats to you in order for you to plead guilty today?
No.
Are you currently on probation, parole, or out on bond on another matter?
No, I'm not.
You understand that a guilty plea could result in a conviction that you may need to report to your current employer?
Yes, Your Honor.
You also understand that a guilty plea can result in a conviction that you may have impact on any immigration or travel status that you may be seeking?
Yes, Your Honor.
You also may need to report a conviction on future job applications. You understand that?
Yes, Your Honor.
Okay, as to the added counts of impaired driving, do you plead guilty, not guilty, or do you stand mute?
Guilty.
And I'm also going to advise you that the killer brew agreement, if the court is going to deviate from that at the time of your sentencing, I give you the right then to withdraw your plea. Can I have a factual basis, Mr. Samaras?
Yes, Your Honor. Mr. Wayne, are you able to hear me okay?
Yes.
Okay. On or about August 5, 2022, were you in the city of Lansing, Ingham County, Michigan?
Yes, I was.
Now, on that date, had you consumed alcohol?
Yes.
And did you subsequently have contact with police?
Yes.
Was it ultimately determined, and would you agree that your blood alcohol level was 0.12?
Yes.
And that was by a data master, correct?
Yes.
And that's what we attorneys call it, a breathalyzer, basically.
Yes, sir.
Okay, okay. And would you agree that your consumption of alcohol visibly impaired your ability to drive?
Yes, sir.
And you eventually did drive within the city of Lansing, Ingham County, Michigan on that day, or on or about that date, August 5th, 2022, correct?
Yes.
Thank you. I think that's sufficient for the factual basis, Your Honor.
Any further questions, Mr. Ring?
No, thank you, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. This matter is set for sentencing on Monday, March 27th at 8:30 in the morning. Prior to sentencing, you need to meet with probation so they can provide the court with the pre-sentence report and recommendation as to how you should be sentenced. You'll also have to undergo a substance abuse evaluation if you've not already done so, okay?
Yes, Your Honor.
Very well.
You need to turn yourself into our probation department in person within the next 48 hours. So by Wednesday at 11 o'clock, you need to be at our probation department so that they can get you set up for the pre-sentence report interview, okay?
Yes.
Do you have
Very
any
well.
questions at this time?
No, Your Honor.
Thank you. Counsel, any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
No, thank you, Your Honor.
Thank you. You're all set, Mr.